India Legal presents Courts Roundup.
Hello, I am Disha and you're watching Courts Roundup. In this program, we bring you the latest legal news and detail of court proceedings. Before we begin, here's the headline. Supreme Court stays Andhra Pradesh High Court gags order on media reporting and social media comments on the content of the Amravati land scam FIR. Supreme Court grants one last opportunity to the Gujarat government for filing reply on an appeal challenging the bail granted to the accused in the murder case of Scheduled Caste youth. Delhi High Court rules that two Indian parties can choose foreign law as the law governing arbitration between them provided there is no breach of justice. Karnataka High Court issue notice to political party to make statement on their willing to issue instructions to its member to wear mask and maintaining of social distance.
India Legal presents Courts Roundup.
The Supreme Court has stayed the Andhra Pradesh High Court's gag order on media reporting and social media comments on the content of Amravati land scam FIR. A bench comprising Justices Ashok Bhushan, R. Subhash Reddy and M. R. Shah passed the stay order on a special leave petition filed by the state of Andhra Pradesh challenging the interim order passed by the High Court on 15th of September. The top court has listed the matter for hearing in January 2021 and has directed the parties to file their counter affidavits in the meantime. The court has also requested the High Court not to decide the writ petition in the meantime. Here's a report.
Supreme Court has stayed the gag order passed by the Andhra Pradesh High Court in a matter related to the Amravati land scam case. The court also issued notice in the plea filed by the state government challenging the High Court direction to bar investigation into the FIR filed in relation to the case. Three-judge bench of Justices Ashok Bhushan, M. R. Shah and Subhash Reddy was hearing a plea filed by the YSR Congress government assailing the gag order passed by the Andhra Pradesh High Court in relation to an FIR registered against a former Advocate General of the state, among others. The High Court had also stayed the investigation in the relation to the Amravati land scam case, in which the FIR registered by the state's Anti-Corruption Bureau named daughters of a sitting Supreme Court judge. Appearing for the state government, senior advocate Rajiv Dhawan submitted that the entire High Court order was based on a letter sent by the state to the Central Bureau of Investigation on 23rd March this year. Dhawan said that a probe was called for on September 8th. A petition challenging the same was filed on 15th September. Appearing for the former Advocate General embroiled in the matter, Senior Advocate Mukul Rohtagi sought to justify the reason for approaching the High Court with such urgency. My client is targeted because he was appearing for the former CM. This case seeks of malafide. This is worse than emergency. CBI did not do anything. My reputation is being damaged. Senior Advocate Harish Salve termed the plea in the Supreme Court as a vote of no confidence against the High Court. He also brought up the allegations made by Jagan Mohan Reddy against the Chief Justice of the High Court. Salve urged the court not to exercise its jurisdiction under Article 136, stating that the High Court could deal with the issue. After hearing the parties, the court issued notice in the matter and stayed the High Court's gag order on reporting of the FIR. The matter will be heard in January next year. The Jagan Mohan Reddy government had mounted a challenge against the High Court order, primarily stating that the order came to be passed in relation to an FIR which itself was not questioned. Moreover, while only one petitioner had moved the High Court seeking relief in terms of protection from coercive action and a bar on media reportage, the order passed by the High Court extends the relief to all the other accused persons as well. The former AG of the state had moved the High Court on 14th September on the grounds that he apprehended coercive steps against him by the state machinery. However, the FIR pursuant to which the AG's plea was filed in the High Court was registered one day later, on the morning of 15th September. This in effect rendered the petition infructuous, the state government contends. Bureau Report.
The Supreme Court has granted one last opportunity to the Gujarat government for filing its reply on an appeal challenging the bail granted to an accused in the murder case, where a scheduled caste youth was allegedly beaten to death in a factory compound near Rajkot. Justice Shah asked the counsel appearing for Gujarat government as to why the state has not filed its counter affidavit on the appeal against the last year's High Court order granting bail. Justice Shah demanded why the state is not filing affidavit even in some other matter. Why are you not filling the affidavits? This will not be tolerated. Notice was issued in this matter last year. Even during the last hearing, the state was granted the opportunity to file a counter affidavit. Why is this happening? And even in other, no affidavit are being filed, the bench said. The Gujarat High Court had on February 4th, 2019 granted bail to the accused. In other words, except presence of the appellant, no any other role is noticed from the statement of the prosecution witnesses and also from the CCTV footage and images obtained from the mobile phone of the present appellant. Therefore, it is not legal and proper to deny bail to appellant on such weak evidence. Further, no any past antecedent is registered against the appellant. The High Court had said in the impugned judgment, the High Court had noted that Section 3 of said SC/ST Act obliged the complainant in opening recital to plead the case that the accused is not the member of the said Act. The Kerala government has moved the Supreme Court challenging the move of the Airport Authority of India to lease out Thiruvananthapuram Airport to Adani Enterprises. The government has moved top court challenging the arbitrary and illegal action of the Airport Authority of India. On 19th October, the High Court of Kerala had dismissed that the writ petition filed against the tender given to Adani Enterprises to operate, manage and develop the Thiruvananthapuram International Airport. The plea stated that the grant of concession to Adani is in violation of an earlier undertaking by the Ministry of Civil Aviation, which has rejected the proposal of state government to form a special purpose vehicle SPV to take over and run the airport on a revenue sharing basis. It is submitted that Adani has no previous experience in managing airport and that granting it such a concession is not in public interest, being violative of the provisions of the Airport Authority of India Act 1994. The plea contends that Kochi International Airport at Nedumbassery, Ernakulam is operated by it and the sponsored Kochi International Airport Limited CIAL is one of the leading airports of world over. Franklin Templeton Mutual Fund has moved the Supreme Court challenging a Karnataka High Court order which had restrained winding up of 6 of its debt scheme without obtaining the consent of its investors by a simple majority. In October 2020, the Karnataka High Court had held that no interference can be made in decision of the trustees to wind up the 6 debt scheme of Franklin Templeton. However, the court had clarified that the consent of unit holders as per the regulation is to be obtained before going through the winding up process. Franklin Templeton, India's 9th largest fund house, had in April notified its investors that it was winding up the Franklin India Low Duration Fund, the Dynamic Accrual Fund, the Credit Risk Fund, the Short Term Income Plan, the Ultra Short Bond Fund and the Income Opportunity Fund, cumulatively worth nearly 28,000 crore rupees. Almost 3 lakh investors are said to be affected by Franklin Templeton's decision to wind up its debt mutual fund scheme. The company has cited lack of liquidity in the bond market due to COVID-19 as a reason for its decision. In June this year, the Supreme Court transferred the petition file on the issue from Delhi, Gujarat and Madras High Court to Karnataka High Court, as the High Court was bound to dispose of the matter within 3 months as per the apex court's direction. Hearing was scheduled even on Saturdays as well as on holidays by the High Court before it pronounced the verdict on 24th of October. The Delhi High Court has held that 2 Indian parties can choose foreign law as the law governing arbitration between them. The order was passed by a single judge bench of Justice Mukta Gupta in a suit instituted by Dolly Sprintex Private Limited, the plaintiff against, and Louis Dreyfus Company India Private Limited, the defendant. The parties enter into an agreement for import of American cotton, which provided that in case of dispute, the same shall be referred to arbitration under the rules of arbitration procedure of the International Cotton Association, ICA. Arbitration under ICA bylaws is conducted under the English Arbitration Act 1996. As per the plaintiff, such an agreement was invalid, null and void, and therefore the arbitration initiated by the defendant was also null and void and deserved to be permanently injuncted. It was the plaintiff's primarily objection that since the contract was executive between 2 Indian companies in India and was to be performed in India, the proper substantive law governing the parties' obligation under the contract can only be Indian law. The defendant opposed the grant of any relief and stated that there was a foreign element in the contract between the parties, as the agreement in question was a high seas sale agreement which was agreed to be performed on the high seas. The court stated that whether 2 Indian parties could agree to a foreign seated arbitration, the court reiterated that an arbitration agreement was independent of the substantive contract. The Delhi High Court has sought a reply from the Central Board of Indirect Taxes and Custom on Bharti Airtel's plea claiming non-implementation of Delhi High Court's order allowing rectification of excess GST worth rupees 923 crore paid by it for the period between July 2017 to September 2017, citing great financial strain. Telecom major Bharti Airtel moved the court seeking implementation of its order dated 5th May 2020, which the court had allowed its plea for rectification and refund of excess GST paid by it during this said period. Airtel stated that in May, the court had allowed the process of rectification to begin, and in pursuance of the order, Airtel had approached CBIC, then CBEC, for beginning the process of verification of its claim and subsequent refund of 923 crore rupees along with interest which was lying with the department. Airtel had also written letters to various authorities following up on the implementation of the order. However, 4 months had passed, but it had received no reply from the department. Now they are saying their special leave petition is listed before the Supreme Court. This is department's appeal against the 5th May High Court order which had allowed Airtel's plea. Advocate Harpreet, appearing for department, said that the department had mentioned that implementing the judgment was not possible and cited technical issues. However, they had been advised by the council that without a stay from the Supreme Court on 5th May order, they would have to implement it. Delhi High Court took cognizance of the charge sheet filed against Umar Khalid, Scheduled Imam and Faizan Khan in the Delhi riot case under the Unlawful Activities Prevention Act, stating that there is sufficient material that proceed against them. After the perusal of the charge sheet and accompanying documents, there is sufficient material to proceed under accused person, namely Scheduled Imam, Umar Khalid and Faizan Khan. An order passed by ASJ Amitabh Rawat, Karkaduma Court said. Delhi police had filed the charge sheet earlier this month for the alleged commission of the offences. Notice of cognizance was accepted by Khalid and Imam, who were present before the court through video conference from the jail. Summons was issued to Faizan Khan, who is out on bail, in view of the fact that issue of supply of hard copies of charge sheet was pending before the Delhi High Court. The court directed that soft copies of the same be provided to all the accused person for now. The first charge sheet in case against 15 people was filed by the Delhi police earlier this year. Accused person include Ishrat Jahan, Safura Zargar, Natasha Narwal, Devangana Kalita, Tahir Hussain, etc. As per Delhi police case, the Delhi riot were part of premeditated, deep-rooted conspiracy which was hatched by the accused person. It is alleged that the accused person conspired to cause disruption of an extent and that such a magnitude that would lead to disorderliness and disturbance of law, and that an unprecedented scale. Delhi High Court has provided relief to an adult woman who left her home to marry the man of her choice. After taking her consent and wishes into consideration, the court noted that being a major, she has a free will to reside wherever she wants and with whoever she wishes. The order was passed in a habeas corpus petition moved by the family member of the said woman, seeking her production before the court. As per the petition, she went missing. A man named Bablu was identified as a suspect for her being missing from her parents' house. The said woman was traced and was produced before the court through video conferencing. The court noted that in her statement made under Section 164 of the Criminal Procedure Code, she categorically stated that she went with Bablu of her own free will and accord, and that she has married him. In light of these observations, the court directed that concerned woman to reside with her husband Bablu. The court further directed that we direct the police authorities to escort her to the residence of Bablu. The police authority shall also counsel the petitioner and the parent of Suleika not to take the law into their hand or threaten either the woman or Bablu. The mobile phone number of the beat constable of police station where concerned woman would reside with Bablu should be provided to both Suleika and Bablu so that they may get in touch with police official in case of need. The Karnataka High Court has issued notice to political parties, Bharatiya Janata Party, Communist Party of India, Communist Party of India M, Indian National Congress Janata Dal S and Kannada Chaluvali Vatal Paksha, calling upon them to make a statement whether they are willing to issue instructions to its member or follower to strictly abide by the rule regarding wearing of masks and maintaining of social distance. A division bench of Chief Justice Abhay Oka and Justice S. Vishwajit Shetty said, prima facie, we are of a view that it is the responsibility of all the political parties to join hands with the state machinery for strict implementation of rules regarding wearing of masks and social distancing. Time has come when even the political party should take responsibility and issue strict instructions to its worker. The direction was given during the hearing of a petition filed by Leskit Foundation seeking strict implementation of the social distancing and compulsory wearing of face mask norm. The petitioner had highlighted that during the political rallies, the norm were thrown to the wind. The statement is made in an affidavit filed in response to the direction issued by the court directing the state government to inform whether it will prosecute Member of Parliament Tejasvi Surya and other political leaders who have violated norms by not wearing face masks during the political rallies. The CJ-led bench has expressed displeasure at the state stance to not prosecute violators of COVID-19 protocols and orally remarked that the intention appeared to protect politicians. The Kerala government has informed the Kerala High Court that the state government is taking steps to withdraw the newly introduced Section 118A of the Kerala Police Act, which was controversially inserted through an ordinance. Additional Advocate General appearing for the state told the same when a bench of Chief Justice S. Manikumar and Justice Shazi P. Shally took up a batch of petitions challenging the Kerala Police Amendment Ordinance, which has introduced the contentious provision. After emphasizing that no adverse action could be taken under the provision during the interim, the bench proceeded to adjourn the matter by 2 weeks. Section 118A criminalizes the communication of abusive, defamatory and intimidating speech. It says that any expression, publication or dissemination of threatening, abusive, defamatory or humiliating content made through any mode of communication punishable if the person does it knowing it to be false and damaging to reputation or mind of another person. A person, if convicted for the offence, could be punished with imprisonment of up to 3 years or fine of 10,000 rupees or both. Earlier, Kerala State Cabinet decided to write to the Government of State Muhammad Arif Khan recommending the withdrawal of the contentious ordinance. The Pinarayi Vijayan-led left government decided to withdraw the provision after criticism mounted with the detractors and political opponent accusing the state government of attempting to curb free speech through the provisions. Following a widespread condemnation, Vijayan had announced that the ordinance will not be implemented for now and that it will be subject to detailed deliberation in the Kerala Legislative Assembly. A PIL assailing the Kerala government's purported decision to do away with the audit of a local self-government fund was disposed by the Kerala High Court after recording the government's explanation for the delay in conducting the audits this year. The petition had been filed by Ramesh Chenithala, the Kerala Legislative Assembly's leader of opposition. A bench of Chief Justice S. Manikumar and Justice Shazi P. Shelley disposed of the petition after taking on record certain circulars and minutes of meetings submitted by the state government. The government had submitted that an pandemic coupled with the state's digital system initial non-compatibility with the software adopted by the central government for auditing led to the delays. This was now being resolved. Audits for remaining municipalities, corporations and district panchayat for the year 2018 to 2019 is likely to be completed by this month, the state informed the High Court. Taking note of the submission, the bench found that the writ petition had lost its relevance and disposed of the petition. The petition has challenged the Kerala government order suspending local government audits for the year as violative of Article 243J, 243Z, the Kerala Panchayat Raj Act 1994 and the Kerala Municipalities Act 1994. These laws require regular yearly audit to be conducted at the local government level, which are to be collected by the State Audit Department and then tabled before the Legislative Assembly, the petitioner had pointed out. And that's all in Courts Roundup. Thank you for tuning in. Keep watching APN.
India Legal presents Courts Roundup.